Hello, this is estate planning attorney and fiduciary investment advisor Jeff Fouts here. We are a firm that specializes in estate planning, and everything we do is geared around helping you achieve several goals, make everything faster, cheaper, and easier after you become incapacitated or die, with less taxes, court, and attorney involvement, of course. And then after you die, we can protect your spouse's inheritance from going to their next spouse and protect their children and grandchildren from losing their inheritance due to divorce, lawsuits, and predators. So we want to use our 32 years of experience to help you have peace of mind and not worry. So our philosophy of estate planning is that you should be as bulletproof as you possibly can be, and that's why we talk about these important topics. Now, in this video, I'm going to talk about part 2 of my 7-part series on how to leave it to your children when you die. As an estate planning attorney, I help our clients get their estate planning in order. And my previous video was part of this 7-part series on how to leave it to your children, grandchildren, or other heirs. In part 1, I talked about making a gift during your lifetime. Now, we move on to part 2, which is called the outright bequest or outright distribution. Outright distribution is a common way to leave assets or inheritance to children, grandchildren, or other heirs. So let's look at how an outright distribution is done. When someone leaves an outright distribution, they do it using their estate plan, either last will and testament or revocable trust or irrevocable trust. Now, the document would say something like, upon my death, I leave everything to my 2 children equally, and it shall be distributed to them outright. If you use a will, your last will and testament will go through probate, but a revocable trust avoids probate, which can save your family wasted time, money, and hassle. So I think that's a good thing. If you use a revocable trust, it could say something like, after my death, my 3 children are each to be beneficiaries of my trust. Each child shall receive 1/3 of the trust assets, and the share is to be distributed outright. Now, if an estate plan simply says, I leave my estate to my 2 children, Bob and Mary, well, that's the equivalent of an outright distribution. Or if it says in your will and trust, I leave everything to my son, Bob, or I leave everything to my 2 children, Bob and Mary equally, or I leave 70% to my son, Bob, and 30% to my daughter, Mary, well, those are all examples of outright distribution. Certain types of assets are usually left using beneficiary designation to make outright distributions. But these type of assets can also be distributed to a trust. So examples of this type of assets usually left using outright distribution include life insurance, death benefits, 401k, traditional IRA, and Roth IRA. But as an alternative, the 401k and IRA and Roth type assets can be handled by a specialized trust if you want those assets to have divorce protection, grandchild protection, and other protection. And so let me emphasize, outright distribution and beneficiary designation may not be the best option to use because the beneficiaries receive their portion outright with no protection. So just want to make that clear. This option we're talking about here today is a no protection option. And if you like that, that's fine. But I believe that outright distribution and beneficiary designation is often not the best option. Then the question is why do people leave assets using outright distribution? And I believe one reason is because it's simple, but simple isn't always the best way. A second reason is really that it's the only option that most people know about. Most people don't know all their options, and that's a shame. And so when you hear some of the remaining parts of our 7-part series, some of the options may be a bit more complicated, but lots of people, once they learn about these options, much prefer those options because of the protections they provide. Some people just want to keep things simple, and they don't care that their assets are not protected from divorce, remarriage, and irresponsibility, medical bills, auto accidents, lawsuits. In other words, sometimes people say, Jeff, look, I just want to keep it simple. I'm going to leave it to my children with no protection. What do I care? I'll be dead and gone. So I don't care what happens after that. It's up to the children to do the right thing with it. And that's okay, but we need to understand what some of the negatives of doing that are. The first negative is there's no divorce protection. And so if they're married when they receive the inheritance, or they get married after receiving it, the assets are likely to get commingled with their spouse's assets. The same applies if it is going down to a grandchild. When the child or grandchild commingles their inheritance with other assets that they have with their spouse, then that inheritance becomes joint property. And if the child or grandchild gets divorced, a jury may make them split the inheritance with their spouse. And that means something bad. It means your ex-daughter-in-law or ex-son-in-law may get a big chunk of what you worked for and meant to benefit only your child or grandchild. Now, a second negative of outright distribution is if a minor, someone under the age of 18, is a beneficiary in a will or trust. If after you die, some assets or amount of money goes outright to a minor, it's a disaster. There's no other way to say it. Courts have to get involved because a minor can't inherit outright or outside of a trust because they're a minor. They can't own it. They don't have a legal right to receive an inheritance without supervision. If a minor inherits outright, the probate court, will have to appoint a guardian and conservator for the child, and the guardian or conservator will oversee the money or assets that you left to the minor. Now, you need to be aware that the court may not appoint the guardian that you would have chosen. In addition, the judge will have input in how the appointed guardian spends the money on behalf of the minor. And on the minor's 18th birthday, when they're no longer a minor, they're over that age, what happens is the remaining funds get dumped in their lap, and now they have access and control over 100% of the remaining amount, even though they're still young, still immature. And so the interesting thing about this is it goes from being pretty restrictive with the court involved, with the court managing everything, to at age 18 with no supervision whatsoever. So it's like, it goes from, black to white, white to black, however you want to look at it. So that's why, in my opinion, you should never name a minor as a beneficiary of your 401k, IRA, or life insurance. You should name a trust, like an IRA Retirement Protection Trust, for that minor. You shouldn't say in your will or living trust that a minor is to receive any type of asset outright. It should only be given to the child in trust for the minor's benefit. In other parts of this 7-part series, I'll talk about ways that you can leave it to them that are better. Now, negative number 3 of outright distribution is that even if you are leaving things to an adult, someone who's over 18, of course, you still need to be careful. If they're not responsible, they may blow through the inheritance or use it for foolish things like I'm being a little, drugs, wine, or fast cars, or women, or men, whatever. I'm being a little facetious, but, that is bad because they aren't taking care of the inheritance that you left them, the money that it took you so long to earn. It defeats the whole purpose of leaving them an inheritance in a way which is meant to benefit them now as well as when they're older. Even worse is if the money you leave them does them more harm than good. For example, if they have a drug problem or drinking problem or whatever that may be. So we must be aware that if an adult child or grandchild is not financially responsible, they will likely blow their inheritance. And that means you should strongly consider not using outright distribution. Now, there's a fourth negative when you make an outright distribution to someone. There's no certainty that any of it will make it down to the child's children, who are your grandchildren. The money or assets may end up going to the child's spouse or to your step grandchildren. I mean, who knows? If you simply use outright distribution, there is no guarantee that it will go down to the next generation, which is probably what you want. That's what most people want. The fifth negative of using an outright distribution is the negative of what happens if you leave money or assets to a child who has disabilities and who is getting or may get government benefits in the future. Leaving an outright distribution to that child or grandchild will likely cause that person to get kicked off of those governmental benefits, or they won't be able to qualify for the benefits in the future until they burn through all your money first, which could be a very big negative. A child who's receiving government benefits can only have a small amount of assets, and leaving them an inheritance outright will cause them to go over that limit and lose the governmental benefits or not qualify for them. Now, in summary, even though using outright distribution or beneficiary designation is very common and it's simple, it has many serious drawbacks and negatives. The remaining parts of this 7-part series will educate you about some of the other options you have, and you need to know all of your options, in my opinion, but including the outright distribution, outright bequest, when you're making these estate planning decisions for you and your family. So a real problem is that most people simply aren't aware of the other options that can provide them with more protection. So yes, in closing, outright distribution is simple and it sometimes has its place, but it certainly has its negatives. I'll be doing the remaining parts of my 7-part series as time goes by, and you don't want to miss any of them. So we are a law firm that specializes in estate planning. Everything we do is geared around educating you as to what all your options are, including options you've never thought of, like IRA Retirement Protection Trusts. You've worked hard, decades, to build up what you have. Assets take a long time to accumulate, but they can go very quickly. For 32 years, we've helped protect assets against spousal remarriage, kids' divorces, lawsuits, irresponsibility, and taxes. And I encourage you to go to our website at FoutsEstatelaw.com, and you can attend our upcoming live workshops or virtual seminars. And more importantly, you can visit with us personally by calling and setting up an appointment. That's no cost, no obligation, at any time, no commitment, and we will always part friends. So I hope you have a good day. Thank you.